We're fortunate today to have two attorneys who are basically experts in the subjects that are going to be covered today. Regina Jackson and Mike Owsley are with the English Lucas Priest and Owsley law firm, which is based down in Bowling Green. Both have tackled many of the issues you deal with, I'm sure, every day. So with that, let's get started. Regina, Mike?
Regina's going to go first. So I told Regina that we're both on the same screen in a conference room, and my name is under her image, and I have no name under my image, and so I guess I'm Regina today, which is fine. It's a compliment.
Whatever works, Mike.
Well, we're really pleased to be with all of you today. We're in Bowling Green, and when I lived in Lexington and practiced law there for a couple of years, I thought Bowling Green was in West Kentucky. But I quickly found when I moved here that there was a whole lot more Kentucky west of Bowling Green. So we're in South Central Kentucky, and we love it here, but I know you all love where you are too. And we can't see everybody on our screen, but as Diane said, we are very happy to take questions. We've broken this up so that I'm going to go, and then Mike will talk about a different related topic, and we're just going to switch back and forth. So we'll try to make opportunity for questions, but if we fail to give you a chance and you have a question, we would much rather have an interactive dialogue with you than just, talk. It's just not as pleasing for us or probably for you as well. So Diane, we'll just let you help us guide that process since we can't see everybody. Okay.
Thank you so much.
Okay. So here's what we're planning to cover today. So our actual title of our presentation is Hiring, Firing, and Everything in Between. And you can see the first 6 topics up there are specifically deal with hiring and firing. And that last topic is one that is something in between, but it's very topical, and that is the EEOC guidance that has just recently come out on COVID-19 vaccinations. Mike's going to take that portion, but we think that'll be a really nice piece of valuable information to all of you. We're going to start then with conducting employee interviews. I'm going to take that one. Then Mike's going to talk about creating effective job descriptions. I'm going to take the following policies and procedures and how important that is. Mike's then going to take conducting effective performance reviews and maintaining personnel records, and I'm going to take the employee discipline and termination section, and then he'll end with that COVID-19 vaccination update. So our very first topic is employee interviews, and I'm sure all of you do realize how important it is to get the right person on the right seat of the bus, and that's pretty challenging right now. We represent the South Central Workforce Development Board, and we have a board meeting today, and one of the topics is, we don't have enough employees to fill all of the open positions, and how difficult it is for our employers to find individuals to fill those jobs. However, don't just hire the first person that walks through the door. You still need to be very careful about who you hire, because you are making a commitment with that person. And, it's easier to hire somebody than it is necessarily to fire somebody. So, you still do want to be selective when it comes to filling positions, even in these challenging days where workers are hard to come by. Why in the world are we talking about employee interviews? It's important because there are laws that protect employees from discrimination, and I'm sure you all are pretty familiar. Can y'all see the top of that screen? Hopefully, Uh, can you see that, Diane? We've
Yes.
got a little bit of a
Yeah.
block over it. Okay. So when you hire an employee, even before they become your employee, you still have legal obligations to that individual under the law. And you all are probably very familiar with protected classifications under the law, and you'll see them up there on the screen. So those categories that you're seeing, race, color, religion, sex, including pregnancy, national origin, age, disability, and genetic information, all of those categories have legal protection. And those legal protections extend to people who aren't even employed yet by you. So if they apply with you, you all of a sudden have a potential legal obligation to them not to make an adverse employment decision in terms of hiring based on one of those protected categories. And just to give you a brief overview, the kinds of laws we're talking about, they're pretty complicated. There's several federal laws that cover categories of individuals based on characteristics. And then, of course, we have our Kentucky Civil Rights Act as well. So one of those laws, which you know, is really pretty familiar, is Title VII of the Civil Rights Act. That's a federal law. And that law prohibits employment discrimination based on race, color, religion, sex, and national origin. And when I say sex, you'll see up there, including pregnancy. And I also want to add to that today, gender identity and gender orientation. So last year, the U.S. Supreme Court issued a decision, you may have heard of it, Bostock versus the Clayton County. And in that particular decision, came out of actually Michigan. It was out of our Sixth Circuit that we belong to in Kentucky. That decision is really important nationally. There had been a conflict among the circuit courts of appeal on the federal level about whether sexual orientation, sexual gender identity was protected under the category of sex under Title VII. Some courts had said yes, some had said no, and the Supreme Court decided that case in favor of the employee. And just to give you a little bit of background about that case, there was a funeral home in Michigan that had an employee, a current employee, who identified initially as male when they hired him. But during that process of being employed, he determined that he was going to transition to female. When he began that process, the funeral home decided to let him go, and they terminated his employment. And that case went all the way up to the Sixth Circuit, and the Sixth Circuit ruled in his favor and said that is considered sex discrimination. And the employer was violated his civil rights when they terminated his employment. So just keep that in mind, that now the definition of sex is broader than just when you think about female versus male. We also have the ADEA. That is, that stands for Age Discrimination in Employment Act. And what that law does on the federal level is it protects employees who are 40 or over. And then we have the Americans with Disabilities Act. I'm sure all of you are at least heard of that act. It protects individuals who have disabilities as long as they can perform the essential functions of the job. And then there's also the Pregnancy Discrimination Act that is specifically designed to protect pregnant women from discrimination and to require accommodations at certain times. So all of those laws are federal laws. And then I mentioned the Kentucky Civil Rights Act that protects all of those categories you see up there, and one other. And if we were together in a room, I would ask somebody to guess what that one other characteristic might be. Unfortunately, we're not together, so I can't just pause for a second and give you a chance to try to guess. But it's actually smoker. Smokers in Kentucky are specifically identified as having a characteristic that is protected. That doesn't mean you can smoke wherever and whenever you want to, but it does mean that when you're hiring an employee, you cannot refuse to hire them simply because they smoke. So that's just a little background of why we're even having this conversation, because Kentucky is an employment at will state. And so many employers think I can let you go for any reason. I don't have to have a reason. And that is, from a very broad perspective, true. But then, we have these laws that serve as an umbrella over that at-will employment doctrine and do give special protection to prospective employees and responsibility to employers to be sure that they're acting appropriately to comply with the law. So when we get into some of the specifics, I'll just pull up questions that if you're interviewing, you absolutely need to try to avoid because they can lead to a problem. The very first one is age or date of birth. You need to be doubly sure if you're using an old job application that you don't have that question on the job application, and you don't need to ask the interviewee anything about their age. I can't really think of a reason that would ever be appropriate or a reason to be some sort of job requirement, except if they're 18. Now that's okay, because remember, age discrimination is 40 or over. So if you're under 40, you don't have that special protection under the law. You also have to you should not be asking questions about whether somebody's ever been arrested. That's probably more likely to appear on a job description. And I've seen somebody's popped up a question there, but I can't read the whole thing. Diane, can you read that? In many of our jails.
Diane's muted. No.
Something.
Sorry about that. In many of our jails, female guards must be present with female inmates. Will identity at hiring or gender reassignment of a current employee still allow for this? Good question, Jeff.
Yeah.
That's a really good question. The law sometimes takes a while to catch up with the reality of the situation that you're facing. I would say that if someone has made transition from male to female and they're now female and they identify as female, they probably
so.
Would have the right to be in the position of guarding or being with your female inmates. But I can't tell you.
Gender is an appropriate qualification if you're looking for a sperm donor.
Yeah, so that's a great question. I would say that in terms of hiring, if you are hiring to fulfill a vacancy of someone to supervise female inmates, it would be an appropriate job requirement that the person be female. But if they have transitioned to female, then I think you have to treat them as female. Okay, so I hope I answered that question, or we did. So in terms of arrest records, you don't get to know that. The EEOC has said that even asking that question creates an inference of discrimination against minority applicants, because minorities happen to be arrested more than non-minorities. Doesn't mean they're guilty. It just means that they're arrested more often in our society. So until somebody is actually adjudicated as being guilty, it really shouldn't come into play. And even being guilty, being convicted of a crime, you have to be very careful. You should only be asking about convictions if it would make the person unsuitable for the position. So if somebody had been convicted of shoplifting, let's say 20 years ago, and you're hiring, that is probably not very relevant today to their circumstances. It's okay to know about it. It's okay to ask about it. It's okay to investigate whether it would cause that candidate to be unsuitable. But just know that you shouldn't have a blanket rule of rejecting someone because they have been convicted. You really do have to get behind the circumstances there to understand exactly what happened and how relevant it really is, how timely it is. Okay. So should you be asking about whether somebody has kids? You know, if you're starting an interview and you're just trying to get comfortable with the person, help make them comfortable, it's pretty natural to talk about, well, you know, tell us about yourself. And if that information is volunteered, that's okay. If you're going to ask questions like that, you just need to be sure that you're not simply or only addressing those questions to female candidates. You should be asking male candidates the same question so that you can demonstrate that you're treating everybody the same. So you need to really make an effort to be fair. All right. Asking questions about citizenship is, that's probably obvious that you should not do that because national origin is protected under the law as a classification that you should treat somebody differently because of availability to work on weekends. I think you can ask someone if they are available, but I think the rest of that equation is the EEOC would tell you that you're supposed to also say with or without accommodation. And that is because there's certain religions that mandate, you know, Saturdays off or that type of thing. And so just know that legally, if someone is unable to work on a particular day, it doesn't even have to be a weekend day, and they are asserting a religious belief as the reason, then you may have to make accommodation for that. And that's true when you're hiring as well. You cannot reject a candidate simply because they might need a religious accommodation. You know, asking about individuals' financial information is prohibited as well, again, because of its adverse effect on minorities. The same is true for, you know, eye color, hair color. There's really no reason. I mean, I can't imagine why you'd be asking that. Why I'd be asking that if I were interviewing, but the EEOC does include it as a category of questions you shouldn't ask. So there must have been some employer out there at some point in time who asked somebody about their eye or hair color. Garnishment records, again, that goes back to financial information, and that's a question that you might like to know, but it's not really appropriate during the hiring process. Height and weight, that is also, you know, not, unless it's a, you know, a police officer kind of position where you do have, I don't know if you do or you don't, but there might be a valid reason to ask. Firefighter, maybe. But unless you really do have a job-related reason to be asking the question, you need to stay away from that one. Maiden name, that also goes back to sex, the sex category, and, you know, asking if somebody's married, or, you know, that gets into, you know, whether you have kids, and, you know, whether your spouse is going to be able to support you so that you really might not need to work. All those kinds of questions aren't really appropriate, as, you know, Mr., Ms., that kind of thing as well. You're not even supposed to ask somebody what their sex is. You know, hopefully you could tell when you're interviewing them, but I don't know. Maybe that's more questionable today than it used to be. And then, as I mentioned earlier, the question about smoking, you cannot ask under Kentucky law. That's not federally protected, but it is state law protected. Any questions about any of that information before we go on to talk about disability related topics.
Good.
Okay. All right. Individuals with disabilities, they have their own law to protect them. That's the Americans with Disabilities Act. They're also protected under our Kentucky Civil Rights Act, and they've got special protections. And you are supposed to avoid asking questions that might cause them to be adversely impacted in terms of hiring. So at least initially, you shouldn't be asking about whether any applicant has any medical condition or their background about being in the hospital, or have you had a major illness in the past 5 years? That's the kind of question that might appear on a outdated job application, whether they're taking prescription medications, whether they have a disability. You're not allowed to know that. Have you ever been treated for drug addiction or for alcoholism? Have you filed a workers' comp claim? I think I can remember job applications that used to have that question.
Yes.
And so that's a no-no. I would encourage you to, if you're not the right person, to get with the right person in your organization to be sure that you are using a very current job application that your county attorney or somebody from a legal standpoint has reviewed, because that's just fraught with problems and can definitely lead to a claim. In terms of the individual who might have a disability, you are allowed to ask these questions. You can't say, do you have a disability or have you been treated by a healthcare professional? But you can focus in on the actual job that you're hiring for, and you can ask whether somebody can perform a job task with or without accommodation. And with or without accommodation, we could do a whole another 2 hours talking about what that means. But you are allowed to ask that question. And you are allowed to ask how an applicant would perform the task and with what accommodations. I had a situation where an applicant who had a leg amputated, I can't remember if it was above or below the knee, but they had an artificial leg, and part of their job responsibility was going to be to drive a tow motor. And so the question, came to me, well, how do we know whether this person can drive a tow motor? And we decided we're allowed to ask, can you drive a tow motor with or without an accommodation, and demonstrate for us how you would do that. So those issues do come up, and they're a little tricky. And if you're not comfortable or sure of yourself, just seek out your county attorney or somebody to help you through that process. Okay. Okay. So I'm nearly to the end. This is my last slide on this particular topic, and I'll turn it over to Mike to talk about job descriptions. But the guiding principle should be, in regard to any question that you are asking a job applicant, is that question related to that person being able to demonstrate a job-related necessity? So is it job related? Is the question job related? If it's not job related, then you shouldn't ask the question. And I would encourage you not to interview just kind of off the fly. Go into an interview with a list of questions that you have vetted, and stick to your script. And for every applicant, you should be asking the same questions. Don't deviate from the questions just because of how somebody looks to you. That is the surest way to stay legally safe anytime you're interviewing. And I'll just add one more quick thing about note taking, and I'll do it through a case that we had where an applicant who was the oldest person who applied for they applied for 5 jobs in the same company over a period of time. And he was always the oldest because he was 60 plus. And he didn't get hired for any of the jobs. The company ended up hiring somebody younger, and they were younger because he was the oldest to apply. But the company did not keep good notes from those interviews. And at the end of the day, he ended up suing the company for age discrimination, claiming I was qualified. He really was qualified. And there was no reason for you not to hire me. It had to be my age. And the company's explanation was, yes, he was qualified. He just wasn't a good fit. And I have said that at times. It's just not a good fit. There's some case law out there that says using the phrase not a good fit as the basis for not hiring someone is code language for age discrimination. So I would encourage you when you are hiring to have your list of questions, but at the same time, take notes or have somebody be a note taker for you and maintain those notes and evaluate your applicants as objectively as you can by providing objective reasons as to why you select one candidate and you don't select the other. And don't use language that's susceptible to interpretation like good fit. And keep your notes. I don't know, if you know this, but the statute of limitations for a claim under the Kentucky Civil Rights Act is not like a car wreck, a year. It's 5 years, which would take us back, to 2016 as we sit here today. So you're susceptible today, going back to June 10 of 2016. You could be challenged even today for something that happened in 2017, 2018, 2019. So not only, and Mike's going to talk, I think, about retention of records, and there's a reason to retain legally because you have to keep records, but from an employment standpoint, you need to keep your documentation about hiring and any kind of personnel action that you might take for 5 years, because that is the statute of limitations. Any questions before Mike talks about job descriptions?
Let me ask a question, maybe get started on this good fit issue. Wouldn't that also apply, that sort of language, as a code for racial discrimination or gender discrimination or disability discrimination?
Yeah.
It's not just the fact of age. Yeah.
No, he had brought an age claim, so I was looking at it from that lens. But good fit language would fit any of those protected categories. And I think the point of this is, and the takeaway is, you need to be, when you're evaluating candidates, have a score sheet or something where you're really looking at objective information about why you're making decisions that a third person, a court, a judge, a jury would say, oh yes, that makes sense. Because when we're looking at things, we're always looking way ahead. What would a jury say if the organization ends up getting sued?
Yes.
Okay.
Any questions, Diane?
One question that
Go ahead, Jeff.
one question that I had was regarding, can you dissect a little bit for me how the different elected officials, they have responsibility for their employees, but overarchingly, the judge kind of does a lot of personnel stuff. So that differential, and then as far as records retention, what of those records, as far as personnel, are eligible for any kind of open records request?
Oh.
Ooh, that's a good question.
No, you're a really good
Yeah.
question.
You want to take the first part?
Let's see. I'd rather have the second. Let's see. We might handle the first part together. So
debatable.
the question is, how do you the county judge executive does get involved in the personnel aspects, but you also have others working in your organization. If you get sued for under one of these laws, typically it's not the individual making the personnel decision who gets named as a party. Typically, it's the employer. And so the law says an employer shall be responsible, et cetera, et cetera. Now, if it's retaliation, that's something different. There's potential individual liability there. So if there's a lawsuit, it's the organization that should be named as the appropriate defendant. How you manage personnel decisions, you really do have to have good people working with you and a good amount of communication, I think, and good process. I think the good process of having a good person, people working with you, and having good processes in place, I think, are the two most critical things. But you
I'd comment on this. In addition to that, what we have seen in the last 2 or 3 years with Breonna Taylor, its death in Louisville, the George Floyd, all of those, there's been a huge emphasis on the immunity question. Police officers have enjoyed a concept of qualified immunity. It doesn't mean they can't be held responsible, but it's harder to hold a police officer, or for that matter, any public official, responsible. But there's, of course, a groundswell movement now to eliminate or to reduce the immunity. Now, whether that'll pass, how it'll pass, what form it'll take, those are all open for debate. But an official who shouldn't get sued because the institution the county government may be responsible, but often does get sued along with others, it's going to depend on whether that person was exercising discretion or whether that person had a duty that he or she was not meeting. I know that's vague, but it is very fact specific and dependent upon what the circumstances are of the individual facts. And I forgot the second question.
Open records.
Open records. Yeah, that's another whole thing. Generally speaking, the presumption is the record is open. I mean, if you start with that, if it's a public agency, there's going to be a presumption the record's open. Not every record is open to the public, but many are. I know I read I take the Courier Journal online. I read in the Courier this morning that U of L has still not provided the records of the lawsuit and the settlement, quote unquote, with Jim Ramsey, the former president of the university, because it is still not finally signed off on. So things like preliminary drafts, those documents are generally not open to open records requests. Certain documents that may invade the privacy of an individual, depending on that person, again, it depends on the person, may be protected from disclosure. The best advice I can give is if you get an open records request, call whoever represents your organization and run that by them. I had one just yesterday where a document was clearly not covered by open records request, but between two school districts. But one school district provided it to the other school district because they thought it would help them with the decision-making process, which is completely wrong. They never should have done it. But that kind of thing happens. So always get advice. It's pretty inexpensive advice to get. It doesn't take lawyers who deal in the area long to give you advice in that area. But that's my best advice when you have an open records request. I don't know if you view it.
Well, no, I view it the very same way. And I would say if, we represent, Mike and I represent several school districts, and they get open records requests all the time. And a lot of those requests are for somebody's personnel file. And, you can't just say, oh, that's private, we're not going to give any part of it. You actually have to go through that file and identify the pieces of paper that really are private that, might be a job evaluation. That's generally would be protected. And records that have some private information and the rest of it not private, like a social security number, you have to redact that, the part that's private out, but produce the other portion of it. And then some records are like a hiring contract, and that's just not protected. I mean, it has to be released. So, you know, it takes some time to go through a personnel file and figure out what you have to produce and what you don't. I think they've just amended the Open Records Act to, I think, say that only Kentucky citizens can make open records requests now. And, you know, you have a pretty short window. I think now it's 5 business days.
I think that's right.
To comply. If you can't comply within that time frame because it's too onerous, too much work, before the 5 days are up, you're supposed to send out a letter saying, I can't get it to you yet, but here's when I expect I can. So there have been some changes in the Open Records Act that are worth knowing about. It's probably not something we can spend time on today. But it's a significant issue, and I know you all are getting those open records requests. And you do need to work with your legal counsel when you do get one, unless it's just very clear to you what to do.
Agreed.
Yeah, that House bill was 312, and it has been extended to 5 days.
Yeah.
Okay, thank you for the clarification.
Thank you.
Dan, should we move on, or is there any other questions this time?
I don't see any more questions, Mike, so I say we move on.
Let me switch gears a little bit. We're going to talk about job descriptions. Probably this topic doesn't deserve quite as much attention as what Regina was giving you on the first part, but it does deserve some attention. So we're going to run through this, and then Diana, you let us know when we're off track time-wise, because I don't think we got started exactly on time, but you just tell us, you know, we've got this broken into about 7 sections, so it's about 15 minutes each, and I think Regina took a little bit more than that, which is fine.
Yeah.
But some will take a little less. So job descriptions, they're important because what you put in that job description, which you're preparing as the employer, the employee is not preparing it. It's going to be one of the, if not the determinant of what are the employee's essential functions. And that becomes really, really important when it comes to disability claims. So under the Americans with Disability Act, an employee has to be able to perform the essential functions of his or her job with or without reasonable accommodation. And you determine as the employer what the essential functions are. So spell them out. It can also help you with defending an unemployment claim if the separation occurs because the employee had refused or failed to perform the job. If an employee, it's hard to win an unemployment claim. If an employee refuses to do the work or refuses to do it's not just an inability, a refusal to do it, then in fact, you may win an unemployment claim as a result of that. It also can be useful in determining whether an employee is exempt or non-exempt for wage and hour purposes. That's too broad a subject for today. It's not covered. But essentially, as you are sure aware, if you're exempt from the provisions of the wage and hour laws, then you don't have to pay overtime. And there's other advantages to that, but you can't make somebody exempt just by calling them a supervisor. You have to actually look at the job and see what their job duties are. So it's important to spell out those duties. It can also be helpful to the supervisor who's trying to measure performance. Look at the job description and see whether or not the employee is in fact performing those expectations. And it can be helpful in the interview process when you're trying to determine whether an applicant is going to be a good fit for the position. So the job description is important, and it should be spelled out. It should explain the task, the duties, the functions, and the responsibility of the positions. It should specify who's going to perform the work, not the person's name, but the title, how the work is to be performed, the frequency of the work, and the purpose of the work in relation to the employer's missions and goals. We do find job descriptions vary all over the map. Some are simple 2-paragraph position descriptions, some run pages. Not sure either one's right, but it'll vary upon the organization's needs in terms of how detailed the description should be. And it's one thing to describe what a tow motor operator's got to do in a factory. It's probably quite another to describe what the accountant's got to do, who's keeping the books. You need to be able to perform a job analysis. In other words, you need to determine what the employee's tasks really being performed are, because sometimes we find job descriptions don't really reflect the true performance. They don't reflect what's actually being done. And one way to do that, if you have an HR function in the organization, which most of you I think would, is that you're going to need to observe those tasks being performed, or someone is, not you personally. And you're going to have to document the knowledge, the skills, the abilities, the physical characteristics, the environmental factors, and the credentials or experience that are needed for the position. Now there's a little chart here. Diane, I guess I should know this, and I don't. Does everybody who's attending this get a copy of this presentation, or is it only on?
No, we send that out, Mike. We send them a copy of your presentation, and also we send them a link to the recording.
Okay, perfect. So I won't spend a huge amount of time on these factors because they're going to be there, and those are the same factors I just mentioned. Knowledge is the comprehension of the body of information required by experience or study, academic study. Skill is an observable competence to perform a learned activity. Ability is the competence to perform the observable behavior that results in an observable product. Physical characteristics are the physical attributes the employee has to have to perform the job duties with or without reasonable accommodation. Environmental factors may be working, outside or inside, or terrible conditions or great conditions. And credentials and experience are the minimum level of education, experience, and certifications that are acceptable. And then once you've taken a look at the job, you need to establish what are the essential functions of the job. And that's really the critical part. I would describe it in a job description that way. Here are the essential functions of the XYZ position. You need to ensure that the task as part of the job function are really necessary or required. We're going to talk about a case in a minute. We're not talking about many cases, but there is one in here we're going to talk about. You're going to have to determine the frequency at which the task is performed, how much time is spent performing the task. For example, if in a warehouse operation, there may be a requirement to lift a heavy object off of a rack overhead, but it may only have to be done once a day, and it may not have to be done once every 5 minutes. That makes a difference as to how frequently the task has to be performed. You have to determine the consequence of not performing the function. In other words, are there severe consequences to the organization if you have essential functions, but they're not being performed, and it would bring your organization to a halt, or at least would slow down your efficiency. You have to determine if the task can be redesigned or performed in a different manner. And you have to determine if the task can be reassigned to another employee. We're going to talk a little bit more about that. The courts are not necessarily just going to accept your job requirements for the ADA purposes. Again, ADA being the American Disability Act, unless the employer can demonstrate that employees have to regularly comply with these requirements. So you can't just put it down as a wish list. It's got to be in fact true. Courts have found in favor of employees who presented evidence that a job requirement in practice was merely marginal, not essential. We did give a little summary of this one case because I think it makes the point, what we're talking about here. In this particular case that we have cited, the plaintiff is a dialysis technical specialist, and he or she, I'm not sure if it's a man or woman, frankly, suffered a non-work related shoulder injury. So it's not work related, it's not workers' comp, and received a medical leave. At the end of that leave, it is a he. I'm sorry, I didn't read far enough. He was given permanent lifting restrictions. He could not lift more than 50 pounds by his physician on a permanent basis. The company wouldn't let him go back to work because the job description indicated he had to lift 75 to 100 pounds, and that was an essential function of the position, as we just talked about a moment ago. The Circuit Court of Appeals, and I guess maybe just take a second, the federal court system, there's the district court, there's one in Bowling Green. And those are the trial level courts. And then appeals from those courts go to a circuit court of appeals. As Regina mentioned earlier, the Kentucky goes to the Sixth Circuit. This one's the Ninth Circuit, which is on the West Coast. So in this case, the Ninth Circuit found for the plaintiff, found for the employee, not for the employer, because he produced evidence that he only had to tilt the dialysis machinery. He didn't have to lift it. And tilting it required him to lift a lot less than 75 to 100 pounds. And another employee in the position confirmed it only took about 40 pounds to lift on a regular basis. So the Ninth Circuit said in favor of the employee that if the lifting of more than 50 pounds was not an essential function, then the company's refusal to allow him to return to work discriminated against him based on his disability. Well, the point of the case is this: what you put in the job description matters. So if you say somebody has to regularly lift 75 to 100 pounds, it better be true. He doesn't have to lift 75 to 100 pounds. Don't put it in there. Because if you do, and the employee can prove that he only has to lift 50 pounds, and he has a 50-pound lifting restriction, then he's going to win a lawsuit. And here's the big thing about those lawsuits. You don't just lose back pay, and you don't just lose sometimes emotional damages. You also lose attorney's fees. So you get the worst of all worlds. You pay your lawyer and you pay the other lawyer. And in some instances, the lawyer's fees are far in excess of the value of the claim. So in this case, I don't know what the lawyer's fees were, but in this case is an example of how the employer's actions wound up costing the employer a substantial amount of money because they didn't look at the job realistically, and they didn't go back and observe what was actually occurring on the floor or on the machinery. So recognize that is an issue that you're going to have to face. So when you're dealing with these issues, job descriptions, you need to organize your data so that they have the same appearance. In other words, the job descriptions, even though different jobs, should be formatted in the same way. So the title, your organization may have a classification. I don't know that it does, but if it does, maybe, if they have a salary range or a salary level, maybe a grade 10 job or a grade 2 job, whatever your organization does. It should show who this person actually reports to. So if this person reports to the supervisor, we'll use the warehouse for a moment there just because it's easy to think of. The warehouse supervisor, that's what it says. Not the person's name, but the position. When it was created, when it was revised, so job descriptions are created, and then they should be dated, and then they can be revised as circumstances change. It should have a summary with objectives, should always outline essential functions, the competency level required. If there's supervisory responsibilities, so if this person has supervisory responsibilities, those should be spelled out. The work environment, which we talked about, the physical demands, that's the 50, 100-pound issue, and others, it could be others. The expected hours of work, it should be a situation where if this is expected the employee is going to work 8 hours a day or longer, that needs to be spelled out. Any travel requirements, any educational requirements, or any experience requirements, and then sometimes not what is required, but what is preferred, even though not necessarily required. So a job description, if it follows that format, it's fairly easy to organize, and then it just is a matter of honestly and reflecting what really occurs. There's something we think you should put into them, though.
Mike.
Yes, ma'am.
Excuse me, before we move on, we have a question.
Yes, ma'am.
Is there a statute of limitations on a workplace injury after the doctor has released that person to come back?
Well, the workers' compensation laws govern that, and what occurs there is that the employee has under the compact up to well, let me rephrase that. I haven't done the comp lately. There's 5 years to file a retaliatory discharge claim when you're penalized under the workers' compact unfairly. That's not the period of time. I apologize. One of my partners does that work, and I can't tell you what that limitation is off the top of my head. There is a limitation. I'm remembering it to be 2 years after the last payment of temporary total disability benefits. So someone's injured, they receive temporary total disability benefits for 3 months or 6 months. And then after those are cut off, there's a period of time. In my memory, and I may be completely wrong about this because I didn't look that up for today, is 2 years, but I'm not 100% sure the 2 years is correct.
Okay, and can an employee have more than one claim for the same injury?
More than one? Well, yes. I mean, let's take a workplace injury. You could have somebody who has injured on the job and has a workers' compensation claim. If he was injured by the failure of a piece of equipment, he might also have a products liability claim against the manufacturer of the equipment that injured him, who was defectively designed or manufactured. He, I suppose, could have a third claim if, in fact, he was not permitted to return to work and he had a discrimination complaint against the employer. So he's got a workers' comp claim, he's maybe got a products liability claim, and he could have a discrimination claim for the employer refusing to permit him to return to work as a result of the injury. So yes, he could have several claims.
Jeff,
We
does that answer?
Call that the Bermuda Triangle.
Yeah, that's
You
true.
know, where an employee is injured, so there's a workers' comp issue, there's a potential Family Medical Leave Act issue, and there's also a potential Americans with Disabilities Act issue.
Yeah, that's true too. Those, I wouldn't even think about FMLA, but that's correct as well. Yeah, I think somebody was trying to say something, Diana.
Jeff, did that answer your question?
Apparently.
I think he shook his head yes.
Okay, all right.
Are there any other questions before we move on? I don't see any, Mike.
Okay, thank you. Interrupt me anytime, it's fine. So we're saying when you're preparing these job descriptions and you have someone in the organization doing that, you want to have a statement essentially saying this, that the duties and responsibilities can change and new duties and responsibilities can be added at any time with or without notice, because we know it's a fluid situation. The other thing we always put, and when we're asked, we're not always asked to put in a job description, is that regular and punctual attendance is an essential function of the job. I mean, if somebody's missing time, we've had employees or former employees contend that was necessary, and it may have been, but if they're missing regularly, that they're not performing their essential functions of the job. So it's important to spell out those essential functions, because if the function's not essential, then it's not, doesn't really matter. It's only the essential functions that really matter. We think that generally speaking, it's a good idea, although a lot of people don't do it, to have job descriptions. So if I'm going to be the employee, I have to have it and sign off on it so that it acknowledges that I understand. I get a copy so that I acknowledge to my employer that I have understand my job duties, and that I understand the description because I've accepted the duties. And they need to be updated. I think we may have mentioned that earlier, when changes are made to the relevant positions, because it's a fluid world we live in, and job descriptions change all the time. For example, I mean, I wouldn't have thought 2 years ago that we were going to have a situation where we're going to have job descriptions where now you're going to be able to work from home. And as a matter of fact, we're seeing some employees in our firm work nearly exclusively from home. Not the lawyers as much as some of the staff members. And then, and I read the other day that I think it was Amazon was forcing employees to come back to work, and they're catching holy hell for it, because employees, some of them don't want to come back, physically to work. They were going to have to come in 3 days a week, I think, or something like that. So job descriptions are, like everything else in this business, is fluid, and it does change, and so you need to keep on top of it. Again, that's somebody in HR's responsibility, but you have to give them the authority to make those changes, or you will get potentially burned. I'll try to answer any other questions, but if there aren't any, we'll move to the next section.
I think you can move on.
Okay.
Okay, great. This is me. And this is a real short section. I think we only have 3 slides under it. It's practical in the sense that if you have a policy and you have procedures, you really do need to know what they say, understand what they say, and then follow them, because there's nothing more. I would rather, as a lawyer, I think Mike would agree with this, you not have any policy at all than have a policy that you're not following.
Yeah, absolutely.
Because it makes it really hard to defend an organization where there's a policy there, but then the policy was just ignored, or there was some reason why the policy wasn't followed. So, that's the big takeaway from this topic. There are obviously legal reasons why policies are important, but there's also just real common sense reasons. If you don't have consistent rules that are being implemented and employees are being required to follow, then it's kind of like Gunsmoke. You just nobody knows what they're supposed to be doing, and it can lead to low morale, low work productivity, and just a poor image in the community and among your employees and among your customers. So there are reasons outside of legal to have consistency when you're implementing policies, but the legal reasons are really important too. So in order to avoid a claim, or to help you avoid a claim, know what your policies say. And again, that work generally falls back on your HR staff to be sure your policies are current, be sure that employees know about your policies, and we like to see a signature on that. I know that's a little bit harder in the electronic world, but if you're handing out a policy, you need to have some means. It could be an electronic signature or some sort of acknowledgement that the employee got it, because if you hand out a policy and the employee can say, I didn't get it, and you can't prove the employee got it, then the presumption is going to be that the employer failed to disseminate it or failed to educate its employees about the policy. For heaven's sake, don't treat people differently, because the very first time you do, someone will be adversely impacted who falls into one or more of those protected characteristics, and it can definitely lead to a legal challenge. So somebody's got to keep up with your history. You need to have some record or some means to know what you've done in this particular instance or this particular situation, so that you're not treating people differently. Because employees remember how Joe Smith was treated or how Sam Smith was treated. And they know when they didn't get the same treatment, or they got worse treatment than their coworker. So it doesn't mean you always have to treat somebody exactly the same, but it's really important that when they're similarly situated, when if you have a rule that says if you come to work under alcohol influence, you've been drinking alcohol and you come to work, and the rule is you're terminated for that, but you terminate one and you don't terminate the next one because, wow, this one was a good worker and you don't really want to let that one go. That's a problem for you. You've got to be willing to treat people the same regardless of who the people are. And if you can't do that, then you're on shaky ground, and you better have a legitimate business reason for making a decision that's different from what your policy says or how you've treated another employee in a similar situation. That's the end of the slide for this section, I think. I think the next topic's up there. But before we go on, I would also say that it's really important when you're looking at policies and procedures to be sure they're current. If you haven't taken a look at your organization's policies and procedures, say in the last 2 years, it really, I mean, we would probably say you need to do it annually, but that's challenging. It takes a while. It takes a long time. I think I've got a client who told me 2 years ago, I'm going to be sending those policies to you soon to review. And I'm still waiting. And I get it. You know, it's a big time consuming project, takes up an enormous amount of energy. Yeah, you almost needed the COVID break to go home and spread it all out and get it done. But it is so legally important. You want, you know, when you get sued, you at least want to be able to know that your policies are in good shape, because they will come into play. Your EEO, your Equal Employment Opportunity Policy, is relevant to any kind of employment claim, including hiring. Your sexual harassment discrimination, or let me take out the word sexual there and just say your harassment discrimination policy. Oh, so important. And you know, that law is evolving. Just thinking about the case last year that we talked about, the gender identity Supreme Court case, you know, that policy needs to be looked at yesterday, if you haven't looked at it yesterday, to be sure that you are appropriately addressing those new issues that are coming up. Back in, gosh, just 2 years ago, Kentucky passed the Kentucky Pregnant Workers Act. You should know about that. It requires employers to provide reasonable accommodations to employees who are limited, their capacities limited because of pregnancy. They don't have to have a disability, so it's not the same as disability. But one of the things that statute says is this language has to be in your handbook. So if you've not gone back in the last 2 years and you don't have that language in your policies and procedures, then you are in violation of the law, even though you don't have an active claim. So just another one is your FMLA, your Family Medical Leave Act. You know, it's just really imperative that policy, your harassment discrimination, your EEO, that you really focus in on those and be sure you've got retaliation in there as a protected right under your harassment policy, or you're in violation of the law without even having a claim. So it just really is important. And, you know, if you're not in charge of that aspect of your organization, you know, go talk with your HR person and ask them, when is the last time that we have had a full review of our policies and procedures? And if it's not been within the last couple of years, it's time. And you might want to actually set an in-depth deadline, or it might not ever get done because we're all so very, very busy. Okay, any questions about that?
I don't think so, Regina, but before you move on, I think there's a question about Mike's last segment.
Sure.
Mike, you were talking about the importance of regular and punctual and something else. Was there, can you refer back?
I think attendance and tardiness we were talking about.
Oh, okay.
Regular, punctual attendance and you know, lack of tardiness is another way to put it. Yeah.
Okay. Chris, did you have a follow-up question about that?
That's what I was looking for. I was trying to write down at the same time, but it was regular and punctual attendance of the employee as a requirement in job description.
Yes.
Thank
Good
you.
work. Yeah, no problem.
Thanks, Chris. And thank you, Mike.
Let me talk to you a little bit about evaluations and reviews. It's one of the things that unfortunately we have to encounter sometimes, and I'll tell you a couple of stories of real cases that are. Had a case one time where a situation where a teacher in a school district, it could be an employee in your organization, it didn't matter that she was a teacher, wasn't performing well and hadn't performed well for a long time. And the superintendent had told the principal, before you evaluate this teacher this year, you're going to sit down with Mike and you're going to go over the evaluation with him in advance. And so I made an appointment, or he made an appointment to come over and see me. and he had filled out in a draft form the evaluation form. And in that form at that time, it was largely check the blocks. You get a rating of 1 to 5 in each category, 5 being the highest and 1 being the lowest. And so he brought me the form and I read through it. And I said, well, you didn't bring me the right form. And he said, what do you mean? I said, well, you told me this employee couldn't walk, talk, and chew gum at the same time. And this form says that she's faster than a speeding bullet and leaps tall buildings in a single bound. He looked at me and he says, well, you can't be honest in those things. Now, I see that all the time, and you probably do too. It is hard to evaluate people. I don't mean it's easy. I've got a case right now where an employee in a senior position was terminated 6 weeks after a glowing recommendation, evaluation. It's very hard to explain how you can have a glowing evaluation and 6 weeks later, you're not worth keeping. So those things really come back to bite you. So I want you to, I hope this doesn't sound too sexist, put on your big boy pants because in evaluations, it is important. Let's talk about them. We think they should be done at least annually. There's not a legal requirement to do them annually, but we think that's a reasonable interval. They always should be in writing, and they should be on a form that has been developed by your organization. There's not a particular form that is the only form to use, but it should be an evaluation form. And it should have an opportunity both for ratings in various categories and for comments because the ratings don't always apply. And there should be in the organization some kind of a policy on evaluations that gives some instruction of when they're to be done and how they're to be done. In some organizations, they're done in connection with an annual review for increases in pay. And some organizations, all of them are done, say, March 1 or whatever date it is. So there's not a requirement that they be done in either of those contexts, but we think they should be a regular basis, whatever your organization, what works for your organization best. If the employee needs assistance, rather than just ask them, give them that assistance to become more proficient. Here's the thing I would ask you to think about. I would say that everybody on this call or this Zoom meeting has at some time or another felt they were slighted in the workplace. Either they didn't get the raise, you didn't get the raise you thought you should have gotten, or you didn't get the promotion you thought you should receive, or you didn't get the job assignment you thought, or your boss is an SOB. You've had some problem in the workplace. That's the jury you're going to face. Everybody on that jury, if there's a lawsuit and if it goes to trial, has had a bad experience at some time in their lifetime with their job situation and their employer, and they're going to transfer that to you. So you're going to have to be really careful that your documentation supports your action, because juries believe that employees deserve a second chance. I do too, unless they're stealing from the company or something egregious. So evaluation, while hard to do and hard to do correctly, is really important. So we want to give employees assistance. We want to let them improve if we possibly can. We don't want to hide the ball. If you've got an evaluation of a document, give it to the employee. If you're doing an interim evaluation because of problems with performance or of an improvement plan, give it to the employee. You need to keep the original. And it says here in the employee's personnel file, that'll vary from company to company and organization to organization. In some organizations, there's a folder just of evaluations. May have all of my evaluations in it. So it'll vary a little bit from place to place and organization to organization. The immediate supervisor, who has a good working knowledge of the employee's performance, should be the evaluator. And the process should always include a conference. It's not just here's a piece of paper where I've evaluated you and there's no opportunity for feedback. It should be a two-way street. The form, you need to design it. There's no magic bullet here, but it should include performance criteria. And under each criteria, there should be descriptors or indicators that can be measured and recorded, whether they're ratings of 1 to 5 or 1 to 10 or some other ABCD situation. And they should be established standards of performance for each criteria. When some, it's easier than others because some are more difficult to measure, somewhat more objective. The form should be specific to each position. Maybe you can use an evaluation form across the board, or at least in a variety of jobs, but I guarantee you the form for the CEO and the form for the janitor shouldn't be the same. Couple of tips. Use evaluation criteria that's valid and observable. I mean, obviously we talked about attendance. If somebody is missing excessive amounts of time, and that doesn't mean you're going to be 100% attendance, but if you're missing excessive amount of time, whatever the company's criteria is, that's a valid, observable matter. If they're not producing the documents and the reports and the other matters they're supposed to produce on time, that's observable. Provide notice, timely notice of these deficiencies to the employee. You don't wait, if someone has an absentee problem, you don't wait a whole year before you bring it to their attention. You may bring it to their attention first in just a comment to them. But let me tell you what, if you make a comment to the employee, even if it's just verbal, you document that you've done that. You go back and you write it down, either in a computer or on a pad of paper that you keep in the bottom left-hand drawer or someplace. That I talked to Regina today about the fact she was late again. She's been late 4 times in the past month, or whatever the heck it might be. Regina's never late, but I've used that as an example. And so you give them an opportunity. And if it continues, then you document that they, in writing, that they haven't improved. So the next time I have a conversation with the employee, there might be a memo that said, I met you back on March the 12th and told you you'd been absent or late 4 times in the last month. You haven't improved. Now you've been late another 4 times or 6 times or whatever it is, so that there is a paper trail, verbal, reduced to writing, and then writing, it's in the form of a memo to the employee. You got to be trained to do that because people will tell you they can't walk, they can't walk, talk, and chew gums, but the paperwork doesn't support it. And you got to be honest. I mean, if the employee is not performing, you're not doing the employee, and you're certainly not doing the organization any favors by saying that they're performing when they're not. And then, unless it's really egregious, you need to have an improvement plan. And here it calls it a plan of remediation. That's okay. But it needs to be how you're going to address this employee's issues, whatever those issues may be. Maybe they don't understand the technology well enough. Maybe they have to have training in that regard. And you give them time to improve, to see if the remediation is going to work. Now, what this document that you're getting here says to use anecdotal records and formal reports of complaints to supplement performance evaluation. What that means is everything doesn't have to be on a performance evaluation, but if for example, I'm getting complaints about Regina from somebody else in the organization, they need to document those to me. It's an email, it's a memo, it's a conversation that gets recorded in some manner, so that it's not just my trying to remember at the end of the year, oh yeah, somebody talked to me about her absenteeism at one time and I failed to write that down. The last thing on here is to be fair and consistent. And by that I mean, don't want to have an evaluation of 2 employees. This kind of goes back to what Regina was talking about at the early part about discrimination, where the 2 employees are doing the same job and they're doing it the same way, and actually they're part of a team of 2, and the white employees' evaluations are all acceptable, and the black employees' evaluations are unacceptable, and they're doing exactly the same work in exactly the same way with exactly the same attendance. That's not supportable. So you want to be fair and consistent in the evaluation. Now, let me stop there because we're going to change topics and see, Diana, if there may be any questions or comments or anybody wants to talk about that.
I don't see any hands raised. If anyone has a question, you can speak up.
I'd say hold up your hand, but I can't see your hands. I'd like to, does anybody think evaluating employees is easy?
I see heads shaking no.
No, it's not easy. It's hard. It's really hard to evaluate employees. And, and it's just not the norm that you want to go to somebody and say, you're you're doing a crappy job. You need to find another line of work. And I'm not saying that that's what you should ever say that in that way, but it is unfortunately required of you as a supervisor to make the employee aware of their deficiencies, to work with them to improve those deficiencies. And if you cannot improve those deficiencies, to make them an acceptable employee to the organization, to cut them loose. And if the jury, I told you about how the juries look at those things, if the jury knows that you've given this employee ample warning, ample notice, and ample opportunity to improve, there will be a greater likelihood that you will succeed at trial. Not a sure thing, but a likelihood.
Actually, I do have a good question here.
All right.
Our participant wants to know if there's any guidance on what is, how excessive absenteeism is defined.
That's a good question. And no, but I think I imagine some of your folks may be SHRM members. I really don't know. The Society for Human Resource Management. They put out some really great publications. We belong to SHRM, and I don't have one that I can quote you right off the top of my head. I think your expectations as an organization should be communicated to the employees as a whole. I mean, if you consider, I don't know what you consider, 2% absenteeism excessive, they should know that going in. If it's 5%, I don't know what it is. I don't know, and I'll ask Regina because she may have a better idea than that, of a specific standard of what is considered excessive. Do you?
Don't.
No, I mean, I don't think there's any there may be some industry standards. If you go in the manufacturing business, I suspect aluminum mill, they have a standard of what is considered excessive in the aluminum industry. But in terms of just across the board, I don't have a standard of what is excessive. No.
Okay.
And I would say about attendance, just be very careful that you are, before you discipline an employee for an attendance issue, and my topic's coming up with discipline in a second, that you're overlaying the FMLA on that.
Mm-hmm.
And because you can step in it pretty quickly if you are dinging somebody based on their attendance and they actually do have a health condition that would qualify them for time off from work, because intermittent leave is covered under the FMLA. And so
That's
that,
true.
A migraine headache could be an FMLA situation where you've got an employee missing once a month and still be covered under the FMLA.
It's tough. It's a tough area to enforce. You get the general attendance concerns, you get the ADA, you get the FMLA, all of those interplay, and you have to recognize that there is interplay between them. Again, the HR person should have in the organization, hopefully you have one, should have a good contact or a good source with whomever is your counsel, your legal counsel, to give you advice in those matters, because it's here's the thing I've also found. I guess I'm digress just a minute. It's much less, we tell clients this all the time, it's much less expensive to get advice to stay out of trouble than it is to get out of trouble. It's one thing if a client calls Regina or calls me and they pose a situation, whatever it may be, and we might spend 10 minutes or we might spend 2 hours. I mean, it depends on the situation, obviously. But believe me, in a lawsuit, you're going to spend months to years of your life and thousands of dollars, and may lose, and may wind up paying the other side's fees too. So it's much, much, much less expensive to get advice to stay out of trouble than it is to get out of trouble.
Good advice, Mike.
Okay, so let's go on to maintaining personnel records. This is kind of a housekeeping sort of thing. What to keep, what not to keep. So in your personnel file, or in the individual's personnel file, you want to keep the hiring records, what documents associated with the hiring. Maybe a job application, it may be a resume, it may be the tax forms that have to be filled out. It may be acknowledgement of receipt of policies and procedures. It's everything connected with the hiring. And you either want to keep the performance records, that is the evaluations there, or in a separate file. Sometimes they're done both ways. And then you'll want a job history. You want to know, if an employee's been with you, when they move from job A to job B to job C, and what their record of promotions or transfers or demotions were during that time. And you'll want to keep the disciplinary records. I mean, again, some of those documents are not going to be subject to open record request, the question that was asked earlier, but they have to be maintained. Don't pitch them, in other words. You want to keep job description, benefit information that's provided to the employee, salary information. These are pretty common sense sort of things. Any acknowledgement they've signed off for a handbook or a policy, if they've received specific training, whether it's training about what the FMLA is, or if it's training about how to build a widget, whatever the training is, their attendance records. But the medical records need to be kept separately under the law. But you need to keep the medical records, but just keep them separately. So you want to keep those kinds of documents. Some things you do want, whoops, I think I went too far. Oh, yeah, I went too far. You don't keep these in the personnel files. Let's say this, you've investigated an allegation against an employee. One employee accuses another employee of doing something wrong, sexual harassment, being argumentative, getting in a fight, whatever it may be. You do have to investigate, but we don't think those documents, they're kept, but not kept in the personnel file. Those documents are kept in a separate folder, preferably by the HR department if they have one, and they can be segregated from the personnel file because personnel file may get subpoenaed. Your I-9 forms, we think you should keep all your I-9 forms together and not in the personnel file. By all your I-9s, I mean for everybody. Your payroll records are usually not kept in the personnel file. They're kept separately. And any what we call personal notes or emails about the employee, let me tell you what I mean by that. If I have personal notes that I have made about an employee, I may not want those to become part of the personnel file, but we need to keep them because they may be needed at some point. You're going to get a subpoena and a lawsuit for the personnel file, and it may define it in a manner that makes it clear that everything is included. But at least in the education field, personal notes of the teacher or administrators are not part of the educational record of the student. And whether that same rule is necessarily applicable in the employment field is not so, but I do think personal notes and emails about employees should be kept, but not kept there. This section is just sort of a housekeeping section of where to keep your documentation. That's really all I've got on that. I think, oh yeah, no, it's not. I went too far. I went too fast. I'm sorry. Keep separate your medical records, any accommodation request. By accommodation request, that's where the employee is requesting an accommodation because he or she has some type of a disability and how that's handled. We don't really have time today to cover ADA and all of the issues involving accommodation and disability. And that's a whole new topic that we spend time on with clients, but just enough to say here today that if an employee is requesting an accommodation because he or she is injured or has some disability that requires some change, keep those separate. We don't think you should keep the background check. You should do background checks, but we don't think you should keep that in the personnel file either, and that's also true of drug test results. And if there's any kind of an equal employment record or affirmative action record where employees have self-identified, for example, you may not ask an employee on the job application whether they're white, black, Asian, whatever. You may track that information. You can ask that information not on the application but after hire, because you may need to track that for EO purposes of what your percentages are for the reports you have to file. And you want to keep garnishment and litigation records separately as well. That was really all that I was going to cover on that. I'll try to answer questions, but it's more of a housekeeping thing of what to keep and how to keep it.
Good, Mike. I see no questions.
Okay, then Regina will pick it up from there.
Okay, so we've got 2 topics left. I'm going to handle the employee discipline and termination, and then I think
that's right.
I think the COVID update is
blast.
after that. So we're on the downhill stretch here. Half hour to go. You may remember in the very beginning, I talked a little bit about at-will employment. And while there are many exceptions that poke holes at the at-will employment doctrine, generally speaking, unless there's some contract or some reason that would deviate from the at-will employment concept, employees are at will, which does mean they can quit or you can let them go for a bad reason, as long as it's not even an illegal reason or for no reason at all. We wouldn't recommend you let somebody go for no reason at all. That's probably not smart business. But what you don't want to do is to take any action that would interfere with the applicability of employment at will. In other words, you want to preserve that employment at will status with your employees. So you don't want to ever make a promise that you're going to employ somebody for a certain length of time, because if you do, then you're locked in and you've got to contractually adhere to that length of time. So stay away from making a length of time promises or entering into contracts for a certain period of time, unless that's some, like teachers, for example, they are employed on an annual contract, and that's by law. So you have to follow the law, but unless there's some law that requires you to act differently, you want to do everything you can not to interfere with that at-will employment. So that's really important in your policies and procedures that you have a policy, or at least some section in your policies and procedures, that actually says employment is at will, and nothing in this policy and procedure manual interferes with that doctrine. It applies to all employees. So that's just, that's important. And then in terms of discipline itself, we talked about fairness, and it's earlier, and treating people consistently, treating them if they're similarly situated, basically the same when it comes to taking disciplinary action. So it's really important. And juries are looking for fairness. They care more about fairness than they do about what the actual law is. So always view a disciplinary situation with what is fair treatment here. And so you do want to look at your policies. You do want to be sure that if you have a policy that has progressive discipline, and you have categories of, infractions that are not severe enough to warrant termination, or infractions that do warrant termination, be sure you understand the differentiation you're making in your policies and procedures manual, so that you categorize the discipline and follow whatever discipline is appropriate for that particular infraction. It also comes back to employees knowing what the rules are. And so I would encourage you to get the rules in some written format, either in your policies and procedures or some separate document that addresses expected work behavior, expected work conduct. So, take a hard look when you're considering discipline at what your policies mandate and follow those. I mean, that is what's going to hopefully keep you out of trouble. And you want to be sure that, if it's an attendance issue, for example, and it's a one-time offense, that's probably not going to result in termination. But if it's progressive and over time you've worked with that employee, the very next absence might be the one that's serious enough to require termination. I saw some questions pop up there, Diane.
Yes, right, regarding at will. Jeff's asked about, he says he understands that when it comes to deputy jailers, the employer must show cause. Is that correct? And is that the only group
Yeah.
regarding at will?
Yeah, you know, I don't know, and I don't know, Mike, if you know. I know there are some special rules for certain groups of, you know, county type employees, and they might be entitled to some sort of due process hearing or that kind of thing. So that's going to be individualized, I think, to your organization and what might be statutorily required. That's not something that, you know, we deal with regularly. I think probably
Aaron Smith in
in
the
our
firm
office.
does, but I don't know the answer to that either, because I don't know if there's a statutory protection for those individuals or not. I'm sorry, we don't know that answer.
Okay, and on this may be a related question. Stephen Stratton wants to know, what about the Policeman Bill of Rights versus at will?
Yeah, there's a special statute, and that's what Regina's telling you is the general law about employment. There's a police bill of rights, and that spells out the rights of police officers. That's correct. Too long for this conversation. Plus, I've had that in 2 or 3 cases, but I always have to look as to what the Bill of Rights is, because I don't ever can remember it from time to time. But there is a policeman Bill of Rights that grants them certain protection.
Okay, well, Crystal, I just heard from our resident expert, Crystal, and she has indicated that maybe Rich Ornstein may know the answer to that. So we're going to see if he can hop on. And in the meantime, oh, there he is, Rich.
Yeah, I'm Crystal texting me. So the deputy jailers, they're the only position in county government that I'm aware of where they can only be terminated for cause, and that's in the statute. So they do have some rights, and there's a case out of Davis County from 15 or so years ago that kind of sets out, I forget something v. Osborne. I forget all the parameters, but basically it's similar to the state merit system, just a simple procedure on how you terminate a deputy jailer. And then as to the Bill of Rights is applicable if it's a law enforcement procedure. If it's just a normal employment procedure, such as Rich Ornstein's late to work every day, then the Bill of Rights will not be applicable. But if it's a law enforcement issue, the Bill of Rights will be applicable, and there's a fairly lengthy procedure that they have to follow.
Thank you.
Thank you, Rich.
Yeah, absolutely. And I'm sure there's this definition of what for cause means there too, you know? So you really do have to get into exactly what the statute says and apply that. And at will, you know, that would be one of the exceptions to at will if there is some sort of statutory code or something like that that would come over the at-will employment status that employers generally can take advantage of. In addition to acting fairly, we've talked about this already a little bit. It's so important to be consistent. So I'll give you an example of a case that I'm trying to settle right now, this week. I don't know if we're going to get it settled or not, but the employer had a rule that, well, so that these are hourly employees. There were 3 of them, and they were in the position of relief operators. I don't know what that meant, but what it meant is, you know, in a manufacturing facility, which is what this employer had, you never want the machine to stop, even though an employee running the machine might need to be taking a lunch break or taking a rest break or going to the restroom. The employer, you know, rightfully so, wanted the machine to keep going. So they had a group of employees, and on this particular night, there were 3 of them, and these 3 employees would go around and they would provide breaks, essentially called relief. They would provide relief to the employees actually most of the time running the machines. And so their work hours, these 3 employees were working the night shift, and they got off work a really strange time, 7:06. Was their clock out time. And the company had a rule that said you cannot, it's treated as job abandonment if you leave work early and without permission. And you can be terminated for that. That makes sense. So they had been in a situation where they couldn't get parts. So they were letting employees on a case-by-case basis leave work early. So an employee approached the supervisor and said, I'm all caught up. It's 30 minutes before the end of the shift. Can I go? And the supervisor said, if you believe that employee, yeah, you can go, and so can those over there. Those over there can also go. So go tell them they can go. Well, it's 2 white men and 1 female black woman who are over there. And they all leave and clock out. The supervisor, when they start looking for the female black employee, and they determine, another supervisor determines that that employee clocked out and her car was not in the parking lot. And the HR manager terminated that female black employee the next day.
But not the 2 white guys.
But not the 2 white guys. And so you can just guess that that has resulted in litigation, where the female black employee is saying, I had permission to go and I left, and now I'm being fired, and these other 2 white guys are still working. And the company said she did not have permission to leave. And so, this has created a situation where the supervisor who said they can go said, well, I didn't know she was in the group. But the male employees are saying, well, yeah, she was in the group. And so it's, there's a factual dispute about what happened, but that, the company didn't mean to treat that employee inconsistently, but a jury is not going to like that. You can just see how a jury is not going to think that that company treated that female employee fairly and consistently with how the company treated the 2 white fellas. And, we don't want to pay the other side's legal fees, and we want to get out of this case as quickly as we can. And so we're trying to get it settled early before we get into a lot of proof. I don't know if we'll be successful, but you just, need to be sure when you're implementing discipline that here I think the company failed in its investigation at the back end. Is where I think there was some failure. But just be sure that you're treating people as consistently as you can based on your own policies and procedures. And if they're similarly situated, which these 3 workers were, you don't want to see that sort of difference in treatment there. Okay, so act legally, which means that if you have progressive discipline, probably you do, or even if you don't, just follow your own rules. That is what will keep you hopefully out of trouble. And always be sure that you're asking yourself, what's a jury going to think about this? Is a jury going to think that we unfairly treated we were unfair to this person? And is there a potential causal connection between that unfair treatment and a protected characteristic that person might be in? In terms of progressive discipline, usually it goes something like this. The process is you start out with a verbal warning. Then if you have a second similar offense, it turns into a written warning. You might have a practice of suspension without pay to give that person an opportunity to consider their behavior and whether they want to still work with the organization. And then ultimately, the most severe penalty is discharge. You shouldn't jump to discharge unless it's really, really bad. I mean, Mike referenced stealing. That's really, really bad. I don't think that would warrant a verbal warning or a written warning. That ought to take you straight to termination, as such, other things, maybe, fighting on the company or organization property, drinking or being under the influence of drugs. Those kinds of things are serious infractions that ought to lead straight to discharge. Most infractions don't, though. They're not. They're, you're absent here, you're tardy here, maybe you make some minor mistake. Those are things that typically you would start out with the least serious disciplinary action and then work your way up to the more serious types of discipline. Document everything, even when you're dealing with a verbal warning. That's an oral communication with the employee. Give the employee a chance to give their side of the story. They might change your mind in terms of whether they had done something wrong. But even then, even if it's verbal, you need to make documentation about it that would say, it doesn't have to be fancy, it doesn't have to be typed. If your style is to keep a notebook, or that's okay, as long as it's legible, as long as it's dated so you can remember when it was, and as long as there's enough factual background to tell us what happened later, potentially 5 years later, that's okay. There's no magic bullet to how you do it, but it is important that you do it. Moving up to the written warning, again, this ought to be handled, obviously, it needs to be in writing. You ought to try to obtain the employee's signature on the warning, just so that you can demonstrate later that the employee got it. If they won't sign, I get this question sometimes, they won't sign. That's okay. You write right on there, refuse to sign, and you sign and you date it. That's okay. It just shows that you've got an obstinate employee. It's okay to also put an employee on a corrective action plan. Sometimes if you do that, though, guess what? You gotta follow up on it. You've got to meet those target dates, and at some point determine whether they've met the plan. Then we go to suspension. Now it's either you've had a repetitive series of events, or you've had something that's pretty bad but might not warrant full-fledged termination. Again, that ought to be in writing. There ought to be some stipulation about that employee coming back to work. And you probably do need to have some monitoring of the employee's performance, after they come back to work. And then obviously the most serious form of disciplinary action is termination. You need to handle that carefully. You need to have somebody present with you when you're terminating an employee. Typically, we would say, tell them why they're being let go. You need to be able to articulate those reasons before the person's terminated. If you can't articulate at the beginning, you're sure not going to be able to articulate after the employee's been let go. So, figure out what the reasons are, and that's okay to tell the employee why they're being let go. Sometimes that frank discussion, is helpful, just in terms of maybe the employee didn't realize what they'd done was as bad as it was. So there can be some closure. It might help with closure. And you should always document those termination meetings as well. Here's a little checklist to kind of go through. You want to see if your policies really have been violated. If you've got a legitimate business reason, that's always the standard. You want to be sure that the punishment fits the crime. So if you're terminating an employee, did you give them a chance to correct their deficiencies? If it wasn't bad enough to warrant termination, were you fair? Again, it's always a fairness issue when it comes to discipline. And we've got about 10 minutes left, Mike. So unless there are questions, I would say we go ahead and move on to that last COVID update.
Anything, Diane, or you want me to go ahead?
No, we're good, Mike. Thank you.
Okay.
Thanks, Regina.
I would guess that you all are probably getting some of these questions because we're getting. I spent an hour on the phone with the client this morning about vaccination requirements. This document, you don't have the whole document, but let me tell you where you can get that. You can get that from the EEOC website. And this is really important because the last part of this document includes changes that were made literally about 2 weeks ago, May 28th. So if you can download that, we're going to cover what's in it, but you can download that, and I recommend you do. It's about 35 or 38 pages long. Not all of it necessarily applies, because what the EOC does when they put out a guidance, and they keep updating it. So they've been putting out guidances about COVID-19 for about a little over a year, maybe 15 months or so now. And so this is the latest guidance, which was literally 2 weeks ago or less. And the reason it's important is we're now recovering, thank God. I mean, we're sort of getting back to the workplace. We're getting out in the community. People are eating in restaurants. People are coming back to work. Although I heard on TV this morning that the Uber rates in, I think it was New York, some guy had to pay $220 for an Uber ride from the airport to somewhere in the city, and his airfare to get there was less than that, because they got up tenfold because they can't find drivers. Anyway, that's a whole nother story, but it's a changing world. And so we need to think about what we're going to do with vaccinations. I will say this, that the issue that I was dealing with this morning, and we'll touch on it here in a little bit, has to do with whether someone is claiming a religious belief that would prevent them from being vaccinated. You get really 2 or 3 different situations here. You get somebody who may be pregnant and doesn't want to have the vaccination while she's pregnant. You may get somebody who has some rare disease that the vaccination is not indicated, like Barr syndrome or something like that. You may get somebody who is claiming that they have a religious belief that is opposed to vaccination. And then, of course, there's a group out there, just the anti-vaxxers, who don't believe in any vaccinations because the government encourages it. So the thing we need to talk about here a little bit on vaccinations is, what is the guidance and what can you do? And our employers are facing this right now today, whether you're requiring it, whether you're encouraging, whether you're offering incentives. What are you doing if people say, I'm not taking it? What can you inquire into? And it's very complex. Essentially, the guidance from the EEOC applies to ADA, Title VII, we talked about, the Pregnancy Discrimination Act, Genetic Age Discrimination Act. We've talked about all those in passing, and we're not going to spend any great time on that except as it applies. Clearly, the EEOC says that employers can encourage employees to be vaccinated. They can provide cash, prizes. I see now that you can win a lottery ticket and get $1 million if you're lucky enough in Kentucky. I think there's 3 of those going to be done. And I think Ohio's offering maybe full college tuition if you take the vaccination and you get into a lottery. Not everybody gets it. And
Kentucky is too.
Oh, they do it? Oh, see, I didn't even know Kentucky was doing it. So
they're going to pick maybe 15.
So there's all kinds of incentives being offered to get people to vaccinate. And generally speaking, that's fine. The rubber hits the road when you say we're going to require vaccinations. If you look at what the colleges are doing right now, and it changes, maybe different tomorrow. I believe that Berea has said they're returning in the fall. You have to be vaccinated. UK, U of L, I think the state colleges, Western, Eastern, Murray, Moorhead, and so forth, are today at least are encouraging but not requiring vaccinations. That may change. Other colleges are dealing with it in other ways. So we want to talk about the proof issue, because some of you may be facing that. Can you require proof of vaccination? You can't ask for documentation that would reveal the answer to vaccination questions, but you can make, and you must make, reasonable accommodation for employees who cannot be vaccinated. And we talked about that. In pregnancy, we said maybe. I would not personally recommend that you require a pregnant employee to take the vaccination, but there's a split of opinion. The information that you're asking about in these matters is medically protected. So if an employee is requesting to be excused from the vaccination requirement, this person, we think, should be referred to HR or to whomever in the management's handling those issues, and handle the interactive process like an accommodation. If they say, I don't want to be vaccinated, why? I mean, what's the reason? You can't get into the details about it. It may be the employee says, I have a medical condition. It may be the employee says, I have a religious objection to it. It may be the employee will say, I don't believe that they're safe. There could be any number of things the employee may say, but it may be necessary to confirm the condition the employee has and actually consult with a provider, a healthcare provider, to determine what potential accommodations should be offered, if any. Recommendation is for the employer to include a statement in the vaccination policy that a request for reasonable accommodation will be considered on an individualized basis. That's what we've done in the ones we have drafted. And some of the accommodations that are possible is if someone says, I'm not going to do the vaccination, and they have a religious belief or they have a legitimate disability, they can be required to wear a mask and to social distance, just like we've been doing now for nearly a year and a half. They can work a modified shift where they're not coming in contact with the same folks. They could be required to undergo periodic COVID testing. They could telework if that's consistent with your organization and possible. It is in some instances, it may not be in some. Or they could be reassigned to a different position if that's possible. Those are just some examples. Again, that whole ADA thing that Regina talked about, reasonable accommodation envisions an interactive process between the employee and the employer as to what the employee believes would be accommodation, and the employer doesn't have to accept the employee's proposed accommodation, but must consider it, and there is a discussion back and forth. Because of accommodation poses an unreasonable burden on the employer, they don't have to do that. But at-will employees, generally speaking, and there's some exceptions, can be terminated for refusing to comply with a mandatory vaccine requirement. You need to be sure you've communicated the following: the details of your organization's mandatory vaccination policy, how to request an exemption, those things we talked about, and the deadline for requesting that exemption, the deadline by which they must have received the vaccine, and any consequences for failing to get vaccinated. The rules are going to be different depending on whether vaccinations are administered by the employer or by a third party. The incentive is for the vaccination of the employee or for the vaccination of the employee's immediate family. And so what we're talking about here, let me back up, is the employee. Here's the hypothetical. Employee, you have your policy, you're going to require vaccinations. Let's say you're not going to offer incentives, you're going to require it. Employee says, I don't want to be vaccinated. I want an accommodation. What's it based on? Okay, the first is, well, it's not the first necessarily, but the one I want to talk about first says, it's based on my religious belief. And they quote some passage of the Bible or some other religious document, Quran, and they say, my religious belief is that no one should be vaccinated because it's against the will of God or whoever. And that's the tricky business, because you can't really challenge the religious belief unless you have objective evidence that that's BS, that it's made up. And we do have some of that, unfortunately, sometimes. The other kinds of accommodations that you'll have is a guy says, or a woman says, I can't be vaccinated because I have this condition, this medical condition, and it's contraindicated. That may be true. There's a few that I understand but they're very limited. So the circumstances are such that you need to be careful how you proceed. We don't have any case law. It's unwinding. I saw in Houston, I think I read 128 nurses were suspended without pay day before yesterday, Tuesday, from a hospital in Houston for refusing to be vaccinated. There'll be a lawsuit. How to come out, I don't know. My advice generally is you don't want to be the first lawsuit. You don't want to be the guinea pig, because you're going to be making law that may be bad law, and you're going to be making it in a highly public manner, and you're going to be out a lot of money even if you win. So from a vaccination standpoint, it's a little tricky. Let me ask this question to the group, Diane. Maybe, I don't know if you can poll the group or not. Does anybody have a mandatory vaccination policy yet?
We have a show of hands. I'm not seeing any hands raised.
Okay. Does anybody have a vaccination policy that offers incentives to get the vaccination?
Okay, I'm seeing some head shakes. Tracy?
Oh. I'm just kind of curious, were the incentives financial, more time off, a bonus, a financial cash bonus? I realize not everybody can answer. I'm just kind of curious what kinds of incentives were offered to get the vaccination. If somebody wants to comment, that's great.
Yeah, I invite anybody who can comment on that. Just unmute yourself and make a comment.
I posted in the chat box, but we were given 2 days off in Woodford County if you got the vaccine.
Oh, okay.
Okay.
Yeah.
Okay, that's pretty attractive. 2 days off with pay. Yeah. There's various ways that's being done. I think that the mandatory policies, they're going to be challenged, even though EEOC says you can have a mandatory policy as long as you have these opt-out provisions. The issue I had this morning, which we really did not resolve, the organization has 175 employees. 100 have been vaccinated, 75 have not. The deadline is July the 1st. 9 have turned in requests for exemption as religious, all of them religious. And of course, that's an easy one for the employee because it's not specific about, that I have this disease that prohibits it or I have this condition. And so we're wrestling with how to deal with that. And probably the 9 won't be all of it. We'll see others, but that was the number as of this morning. I don't know exactly how we're going to deal with it yet, but the mandatory policies are going to run risk of you're going to be in litigation. Some of you are going to be in litigation. The incentive policies, you probably aren't. So I would encourage you to think about that because the litigation costs could be significant. And in addition to the legal cost, even if it's covered by your insurance company, the time you're going to be involved to have to spend as a management person is going to be significant. That's about where we intended to stop, Diane. We've tried to answer any questions.
Okay, that's a lot of information. Does anyone have questions? Because we really don't want to leave. If you do have, we don't want any unanswered questions.